ladies and gentlemen, welcome to Chapter 1 Trademark Seminar. This seminar will be in English. Of course, for the convenience sake from our Chinese friend or Mandarin speaking friends, I would put some of the important notes, okay, in Chinese. For your better understanding. So, as I said, in this Chapter 1, I will be introducing what is trademark. Okay, so I will start off with the introductions to trademark laws. Then I will proceed with the trademark application procedures or the process of applying a trademark in Malaysia. Next, I will be dealing with many things like the objects, property rights, ownership, and most importantly, interestingly, I add on the criminal offenses, the offenses and enforcement procedure under the new law. So this is something very new to us. And we have just enacted the act last year in 2019. Let me start off with explaining what is trademark. So if you look at the definition under Section 3 of the TMA, TMA means Trademark Act. It means any sign capable of being represented graphically, which is capable of distinguishing goods or services of one to another. Now, sign. You see, the word sign may sound haunted. Okay, imagine you are in a haunted house. And of course, haunted means, you know, you're looking for signs of the kind of appearance, okay? And you can feel it, you can see it. That is called sign, basically, in a layman term. Of course, if you look at Section 2 of the Trademark Act, signs a sign includes any letter, word, name, you know, branding, heading, label, tickets, hologram, sound, color, or any combination of thereof. So meaning that you can register all this under the trademark laws. So what do you mean by graphically capable of distinguishing goods or services? You see, the purpose of a trademark is to distinguish your goods and services from one proprietor with another proprietor. That is the function and that is the main purpose of a trademark. They call it distinctive character. So if you really want to have a what they call it, in order to successfully register as a trademark, registrar will look at how distinctive is your character of the trademark. So when you design a trademark, please pay attention to this distinctive character, all right? Because this is very important. I shall explain it later in the coming slides. We have two types of trademarks here. The traditional trademark and the non-traditional trademark. Some people call it conventional or non-conventionals. Before the new acts in 2019, we only allowed to register the traditional trademark, which comprises of letters, words, symbol, logo, slogan, name, numbers, you name it, okay? However, under the new Act 2019, the non-conventional trademark was allowed, such as the sound, colors, motion, hologram, even positions, 3D, the smell, everything. All right. So let me give you an example of traditional trademarks. This is a symbol, as you know, this Nike and Secret Recipe. And I'm very happy to have him as our clients. Ambercha, these are some of the trademarks that I successfully registered for them for the past few years ago. So you see your personal name can be a registered trademark, okay? If you're famous celebrities, go and register your trademark today, your name, all right? Because you can license out to anybody, you know. You might not manufacture the things, the product yourself. You can just license out. I will talk about licensing later on in my slides. Okay. Oh, this how beautiful is my girlfriend. Sorry, this is not my girlfriend. This is Amber Cha. Okay. Her name is Charlie Peng, and she's a registered trademark owner. Okay, this is just one of the example I want to show you. All right, here are some of the non-traditional trademarks, such as the sound, the motions, okay? So sound, yes, the sound you can register the sound, okay, as trademark. This is fall under the non-traditional trademarks, okay? Holograms, even colors, combination of colors, shape of the goods, the positions of your trademark, yes, these are all non-traditional trademarks. Okay, fair enough. A very brief understanding of our non-traditional and traditional trademarks. So now let's come to the important part here, the application process. Okay, so what you should do how we should go about to register a trademark. You see, applying for a trademark is not like renewing your car license. Okay, you can get it immediately done, or you can get it overnight. Okay, so it takes time. Let me show you the process of trademark applications in Malaysia. Of course, the first thing you do is, this is optional. Okay, I will recommend my clients to I will help them to conduct a trademark search, of course, to check any similar, identical trademarks, or maybe to check any, I would deal with the similarity and the identical trademarks in the coming chapters, but I will just carry on for these slides. Okay, the first step, we file in our trademark applications. In the next 3 months, probably, the MIPO office, the trademark registry, okay, will conduct the formality examinations. Okay, this is a preliminary examinations. Basically, they just want to check, see, and to check your formalities, such as, have you fulfilled the statutory requirements? Did you give them a clear picture, a clear representation of the trademark? Or else your trademark will be, they will send you a provisional objections, okay? And you have to fix that as soon as possible, probably within 2 months. Next, in the next coming 6 months, probably, okay? Now the deadline can be more or less differ or varies depending on the backlog of each examiners, all right? So please do not quote me for the time frame. It's just a reference. Now, during the substantive examinations, we will check thoroughly. We will check thoroughly on everything, okay? From every requirements under the trademark law, not just the similarity or perhaps identical trademarks. We even check to the extent of whether trademark had offended any laws. Okay. Okay. So if during this examinations period and the registrar or the examiners raise a provisional objections to your applications, they will send you a notifications of the so-called the refusal, or maybe the objections, and you probably have 2 months time based on the standard Malaysian 2 months time, and it can be extended up to maximum only 6 months to respond. You have to reply within the 2 months. Now, if you need extension of time, yes, you have to pay for the penalty. Okay, that's how they, how they gather a lot of funds, maybe. So you need to file a response. And if during the examination period, and if it was found that you have passed all the requirement, all the tests for examinations, and your trademark applications will be accepted and published in the Intellectual Property Official Journal. So when you publish in the journal, what happened next is that for the next coming 2 months, any third party may raise oppositions, may oppose to the registration of your trademark, and by filing in a notice of oppositions. Now, if someone did so, it's very unfortunate that we have to commence the opposition proceeding here, all right? And it will take about, probably, I would say from my experience, about minimum 8 months to a year or more, to resolve these opposition matters. Now, if there's no oppositions raised during this 2 months, congratulations, you will get your registrations. You will get your final registrations, okay? You'll get your your certificates. They will run you a certificate and of registration, and it will last for 10 years. Do I have to renew every year? No, you don't have to renew every year. You just renew once every 10 years. And the registration validity period will start or commence from the first filing, the priority deadline or the application date. Okay, I'm sure this is very simple enough. So some of you might ask me, I have found my trademark for years. Can I request or maybe I need to sue somebody, I'm encountering an infringement, okay, or maybe a potential upcoming infringement case, and I wish to sue somebody for infringing my trademarks. And what can I do with my trademarks? Because my trademark is still pending for registrations. Yes, okay, you may request for the expedited examinations. Expedited examination means that you request to the registrar of trademarks to expedite, to expedite your examinations. All right. However, not every reasons are acceptable. You need to fulfill some of the statutory reasons, okay, such as is due to national public interest, or maybe there's an upcoming infringement proceeding taking place, and then perhaps you need to register the trademark in order to obtain some monetary benefits from the government or any institution recognized by the registrar, okay, or any other reasonable grounds. So not every reasons, okay, are accepted by the registry to expedite the examinations. For renewal of trademarks, as you know, every registered trademark will last 10 years from the date of filings or the priority date. So you need to renew it every 10 years, once every 10 years, okay? If the renewal fee is not paid, okay, before the due date, is not paid before the due date, there will be a late renewal fee charged within 1 month from the expiration of the last registration. All right, so just be very careful with your registration, because if you don't renew it, your trademark will be deemed abandoned or withdrawn. Now, many people are not aware that your registered trademark in Malaysia can be cancelled or expunged by a third party on the ground that you never use it for more than consecutive period of 3 years, okay, before the so-called after the registration of your trademark, okay. So by doing so, you have to go by the court way. You have to file the cancellation actions, we call it, through the High Court of Malaysia or through any high court in Malaysia. You do that, you need to show proof that, the plaintiff must show proof that the defendant did not use the trademark for consecutive 3 years after they obtain registrations, okay? And that's why I said, I always recommend clients, please, you must use your trademark after you get it registered, okay? Use doesn't mean that you have to sell, or you can use anyway. You can use it by advertisement, you can use it by giving sample away, that's using your trademarks, all right? However, this is not automatic. Don't worry, this is not automatic. The aggrieved party, the third party, must file a lawsuit, okay, through the High Court of Malaysia to cancel off your trademark. Now, who can register a trademark? Section 17 of the Trademark Act say that any person who claims to be bona fide proprietor Bona fide proprietor. What is meant by bona fide? Bona fide means good faith. Okay, you must register the trademark. When you apply for a trademark, it must apply in good faith. All right, in good faith. So, okay, in good faith. Now, what happened? What is the bad faith? Bad faith means it's not good faith. Simple as that. Let me show you one case, okay? This is a very interesting case study in Malaysia. This is a federal court case, all right? This case is concerning the what is bad faith, okay? Bad faith registration. Now, case is about Lo Chi Yong versus, okay, Lo Chi Hong. See, these two are brothers. Then this is a real case. It's a very recent authority, 2018, as a published authority, published cases, law cases from the Federal Court of Malaysia. The Federal Court is the highest court, okay? So you have the High Court, Court of Appeal, and the Federal Court. So why from Federal Court? Because all these two parties appeal all the way to the Federal Court, which is the ultimate court, all right? So the Federal Court, let me just explain and let me tell you a bit of the facts of the case. Now, this case was involved the trademark Renox, and it was registered under the sole name of the appellant. LCY means Lo Chi Yong, this guy. Okay, so since 13 May 2005. So Lo Chi Yong, the appellant, okay, to the Federal Court, in this case is the appellant, all right? Lo Chi Yong, let me just call him Lo Chi Yong, LCY, okay? It's easier for you to understand. Now, he registered this trademark called Renox, R-E-Y-N-O-X, in his own personal name, okay? Since May 13, 2005. Now, please take note of the time frame here. And then a partnership was formed between the appellant and the first respondent. Means that Lo Chi Yong and Lo Chi Hong eventually form a partnership, a business partnership, okay? And to maybe, to run some business, okay? And then the partnership then evolved and they form a Sendirian Berhad. They call it a sole what they call it, a company, a limited share company, all right, in Malaysia. They then form a new limited share company to run the business. Doing what? Using Renox trademarks. Now, during these two stages, there is no transfer of ownership of the trademark from LCY, Lo Chi Yong, to the company. All these whiles, the trademark was registered in the name of Lo Chi Yong. Then what happened? Okay, appellant allowed the second respondent to use. The second respondent is the company here in this case. So Lo Chi Yong allowed the company to use the trademark. Okay, to use the trademark. And then eventually, when they broke off in 2013, I believe, I cannot see the slide here. Okay, the consent to use the trademark was withdrawn. I say, hey, I'm the registered owner of the trademark, and now I stop the company from using my trademark because I wanted to take it back. All right. So of course, in the first instance, the High Court, Lo Chi Hong, maybe the brother, did not agree to it, and then they keep using it. Of course, you can expect Lo Chi Yong to be very mad, and then they filed a lawsuit against Lo Chi Hong. So this is so they are selling the liquid fertilizers, Renox, okay. So, and of course, what happened? Lo Chi Yong filed a claim against respondent for trademark infringement and passing off of his trademark. And in the response, the respondent, Lo Chi Hong, counterclaim. And they claim that you, Lo Chi Yong, you register the trademark. The way you do it is by obtaining by fraud. Okay, you are registering the trademark in bad faith and by deceptions. Now, this is what we call bad faith, okay? We are talking about bad faith issues here, all right? And then according to the respondent through his lawyer during the submissions to the learned judges, okay? The trademark was registered under the name of the appellant first, and then they promised and then the appellant promised to transfer to the company, but the appellant didn't do so. So what happened? In the first instance, the High Court allowed the appellant claim. That means Law Chi Yong won the case in the High Court and dismissed the respondent counterclaims. And of course, Law Chi Hong, you know, the losing party, of course, in the High Court, and he's not very happy about the result. And then he appealed to the Court of Appeal. So what's next? In the Court of Appeal, the appeal was allowed, meaning to say that Law Chi Hong actually won the case in the Court of Appeal. And you can expect, and of course, when you won the case, the High Court decision was set aside by the Court of Appeal. Later, Law Chi Yong appealed to the highest court in Malaysia, which is the Federal Court. Okay? And at the end, the Federal Court actually set aside the decisions of the Court of Appeal and reinstating the decisions of the High Court. Meaning to say that, in other words, Law Chi Yong won the case at the end. So according to the Federal Court, you see, all these whiles, the issues, there are two issues here the issues for trial, and there are two issues here to be determined by the court. The first issue was that whether the trademark registered in the sole name of the proprietor at the time was Law Chi Yong was bona fide, was done in bona fide. What are you applying in bona fide? Okay, whether the registered proprietor owned the valid trademarks. Okay, of course, these two are one of the main issues to be determined by the court. Of course, the High Court decisions in this case that the claim was allowed and the respondent counterclaim dismissed, the court held that the appellant is the registered owner of the trademark and there's no fraud in the registrations. And therefore, Law Chi Yong have exclusive rights over the trademark. Okay? Why? Because if you look back at the time frame, Law Chi Yong, he registered the trademark in his own capacity, personal capacity, before the commencement of the business. So there's no fraud here because everything was done properly accordingly. Now, if you twist the facts around, let's say, if you and your partner, you start a business, and then the business is running on this what they call it, on this using this particular trademarks and all this thing, and then you went out and tried to register the trademark in your own name. Can you do that? The answer is no, because you've done it in the bad faith. Okay. However, in this case, Law Chi Yong and Law Chi Hong, the court say that Law Chi Yong done it in a good faith. Okay, because he actually applied to register the trademark before the commencement of the partnership and the subsequent companies, the business. Okay, so there's no bad faith and the trademark was not obtained by fraud or deceptions. Okay, so this is one of the case law authority. Now let's come back to the Trademark Act. Section 18, there are changes in the new act which allows multiple classes. So previously, when you file for more than one classes, for those of you who are not very familiar with the trademark law, trademark applications, I just want to tell you that under the NIST classification, there are 45 categories of classes. We call it classes of you may choose to apply for your trademark registrations. So in the previous practice, when you file for more than one classes, you need to do it separately. You need to fill up, let's say if I want to file 5 classes, I need to fill up 5 different individual forms. And then I have to submit one by one. In this new section 18, you don't need to do that. We can just file in one application with many classes. However, the governments, they will still charge, not the same, they will charge separately for each and every classes. Meaning that if you want to, if let's say I charge you 100 for one class, if you file for 5 classes, you have to pay me 500, okay? Now, so section 20, some of you with colors, with very beautiful, distinctive colors for your trademark, you may actually, when you apply for a trademark, you may apply with colors. Why? Because I strongly recommend it, because it will serve as a distinctive feature for your trademarks. It's so beautiful that everyone, when you look at your trademark, they can simply recognize your trademark. So that is called distinctive, all right? So I will encourage you to do that. However, is there any limit if I file in black or white, and can I use different colors later on? Yes, you may do it, because there's no limitation to color if you file for, if you do not limit to as to any colors, all right? So series trademark, let's say if I have 5 up to 5 or up to 6 different series, okay? But I'm sharing the same mother, I call it the same mother trademarks. So the mother trademark has many children, like I put it, I call it Alibaba, Alibaba 100, Alibaba 200, Alibaba 300. Should I register for all the Alibabas, all the children of the trademark? The answer is no. You may choose to register under the so-called series trademark. Section 21 of the Trademark Act provide any person may file a, may apply a series up to 6, okay, up to 6 various trademark in one single applications, all right? And how, because the trademark only differ, the children of the trademark, they only varies and differ in respect of one of or more of the followings, okay, such as numbers, pricing, quality, font size, everything. However, it does not affect the mother of the trademark. Let me show you some example. All right, my client, Secret Recipe, they file for a series trademark. You see, they have HR and HR, okay? So this is one of the example of a series trademark, because in the 2 different positions, you don't have to file these 2 separately, all right? It's just the way you position the trademark, but the mother of the trademark, HR, is still there, all right? The logo here is still there. Now, this is another example of a series trademark. This is a white and a black, colors, the positions, etc. Okay, now we come to trademark as an object of the property. If you have a very well-known trademarks, okay, if your dad owns a very well-known trademarks and he doesn't want to pass on and inherit you with all his property, real estate property, I mean, never mind, you can ask for the trademark as an object of the property. You can ask him to assign to you, okay, the registered trademark. Because a registered trademark under Section 62 of the Trademark Act, it says that it is like a personal property, just like your car, your houses, your real estate. It works the same, all right? It works the same. You have a title, you can assign, you can do whatever with the title, okay? 63, Section 63 says that if there are 2 owners or 2 applicants or 2 owners, okay, to a trademarks. So in the absence of any written agreement between the 2 owners, the 2 parties, under the law, they shall own the trademark equally, okay? Equally, understand? So under 63 of the Trademark Act, if you want to assign, let's say if you have 2 parties, jointly owned parties, okay? Equal share partnership of the trademark. Can I assign my trademark to a third party without the consent of the others? The answer is no. You cannot do that. You cannot do that. So you cannot even grant license, you cannot even charge or whatever to do with the trademark without their consent. According, of course, I understand that if you watch this video, this live broadcast, let me remind you, okay, that under the Company Act, if you want to dispose of your trademark by law, okay, you should hold an EGM for it, because disposal of trademarks considered as an asset for the company. Okay, when you register, you do need an EGM to register a trademark. However, when you want to dispose, when you want to assign the trademark, the company's trademark, to another parties, okay, by law under the Company Act, you need to have an EGM. Okay, the shareholder must approve to the assignment. All right, unless it's a private company, you own the company, okay, fine, no problem. Okay, I don't need that. The director will just sign off. Okay, I'm happy with that. However, strictly speaking, I'm talking about some companies where you have so many parties here. You have to take, just beware lah. Okay, just beware. So under 64 Trademark Act, registered trademark can be assigned like your personal property. And 64 subsection 5 says that a registered trademark may be the subject of a charge. Okay, like your personal property. So what do you mean by charge? So you see, when you go to the bank and you want to get a loan for your house, we call it mortgage. So the bank would normally file a charge, a caveat, okay, something like a caveat, a charge, a registered charge over your house. Okay, so they will possess ownership of the house in case you defaulted or what. All right. So this thing works the same for your trademark. Now in the old act, there's no mention of charge here. Okay, only under the company law. However, the new amendment to the trademark actually specified that under section 64(5), you may charge your trademark like your personal property. So you have a fantastic, very well-known trademark. Perhaps one day, perhaps one day in the future, you may actually get a loan from the bank, or maybe you can actually get a loan from any investors or your friends by charging away your registered trademark. So this is a sample of a assignment. Okay, so once you assign the trademark, they will give you a certificate to it, and I can show that to you because it's a public records. Now all your trademark is public records. Okay, who owns the trademarks? Okay, we know who is the owner and who is the so-called the address for service, etc. Fine, let's come back to licensing. Now, you have fantastic ideas. You have a registered trademark, and then you want to, maybe you run a few very successful ventures, business, and then you would like to venture your expand your business by licensing out. So what should I do? Okay, now under the old act, there's no mention for licensing. Licensing usually done under private, we call it private one-to-one by contract, by way of contract. However, under the new law, the new Trademark Act 2019, there's a provisions for licensing. Now, let me just briefly introduce about licensing, okay? Licensing and franchise are totally two different things, okay? License is a permission to use your trademarks. So we have two types of license here. One is the exclusive license and the non-exclusive license. And of course, under each license terms, you may specify general terms, or you can specify any limited terms onto your licensing agreements. Okay, section 69, subsection 1. It says that license can be both, maybe general or limited. So what's the limited license? Limited license, in other words, is to limit the goods and services that you're selling, or in relation to the use of a trademark in a particular manner or particular locations. So I can license you to operate my bubble tea, for example, maybe in a specific shopping center in maybe Kapong or Cheras or Kuala Lumpur. So I may specify a territory for you. I may even specify what type of products you can sell and you cannot sell. Okay, that is called limited license. All right. Now, under section 69, subsection 3 of the Trademark Act, a license shall not be effective unless it is in writing and signed and on behalf by the grantor. So you cannot just put it like verbally agreed. It must be in writing, okay? Black and white, writing, agreement. So in the agreement, you must spell out whether you are exclusive or non-exclusive and the limited or general terms on it, okay? So what is an exclusive licensee? Section 71 and 72 actually deals with the exclusive license. Now, the difference between exclusive and non-exclusive license is that exclusive licensee may bring an infringement proceeding against any third party, okay, other than the registered owner, and in the name of the registered owner. Okay, so I don't have to ask permissions. Okay, I don't have to ask permissions from the registered proprietor of the trademark, and straight away I can actually get my lawyer to sue somebody if they infringe my license. That's something exclusive license. Okay, and all this licensing you have to actually so-called registered with the you have to submit a copy. We have to deposit a copy with the trademark office. All right, they call it a recorder of license. Yeah, okay. Now, what about non-exclusive licensee? Okay, this poor thing. Well, basically under section 70, you cannot simply sue somebody in the name of the registered proprietor. You need to serve the notice to your own registered proprietor that you intended to sue somebody, okay, for infringement. And of course, under section 73, Trademark Act says that within 2 months, if there's no response from the registered proprietor, licensees may bring the proceeding in his own name as if he were the registered proprietor. So if I want to sue somebody and I'm not exclusive, all right, I have to ask permission from the trademark owner. And of course, under this Malaysian Trademark Act, in 2 months' time, you don't do that, I can sue the third party, whoever who infringed my trademarks in my own personal capacity, okay? But I have the rights, I have the standing. We call it the local standby, okay? I have the rights as though as I were the registered proprietor. Okay, fine. And then so far, everyone happy? Are you falling asleep? If not, please give me a thumbs up. Oh, thank you, Dharma, Vishnu. Thank you. And I hope I will continue with the offenses and the enforcement. This is something very, very new to the Trademark Act, and I want you to really pay attention to it. And seriously, I don't think any videos or broadcasts ever taught you on this particular sections here. Under the old Act, the Trademark Old Act 1976, there's no mention on offenses, on the criminal offenses. When I mention offenses, mean it's criminal, okay? It's not civil, it's criminal, all right? Under general offenses, all right? And all the enforcement, okay, of maybe counterfeiting, all this must be undertaken under the Trade Description Act. However, we call it the TDA. Now, under the new law, which repealed the previous 1976 Act of the Trademark, from 2019 onwards, okay, December 23rd, this new law came into effect. And then now we have the offenses here. All right. Listen carefully if you are a registered trademark owner. All right. I'm here to tell you your new rights to trademark and some of the benefits that the governments of Malaysia can offer to you for free, okay, or very less cost, in order to protect the what they call it, the owner of the trademarks as well as the consumer. Counterfeiting. Counterfeiting means when you make an identical or similar registered trademark which belong to another intent and is with intention to deceive. Section 99 of the Trademark Act says that, okay, of course, this is without consent. Now, in other words, if you are manufacturing, if you are making and you're falsifying a genuine registered trademark, whether you by alteration, you add on effacement or removal or all these things, of course, without the consent from the registered proprietor, you commit an offense, okay? No counterfeitings, all right? Example, you take a branded, maybe it's one of the branded sports shoes, okay? And you just copy and you make identical products out of it. That is counterfeiting. That is illegal. That is criminal as well under Section 99 of the Trademark Act 2019. If you are found committed an offense, you will be fined not exceeding 1 million ringgit and or to an imprisonment not exceeding 5 years or both. So please don't sell, you know, for those of you who do 网卖, 微商, people say, or maybe online Shopee or whatever, do not sell counterfeit products, all right? Be very careful when you source products from your supplier. Make sure that it's genuine. Make sure that you have your own registered trademark. If you were caught doing so, you can be fined up to 1 million ringgit for counterfeiting. Okay, this is criminal offense. Section 100, falsely apply a registered trademark, okay, to the goods or services. Now, if you use, you know, other people trademarks without their permissions, okay, although you are not making, you're not counterfeiting the products, but you just basically apply it and put it in your own products, okay, put it in your own products, you will be fined as well, okay. Under Section 100, you will be fined as well. And then let me see, what's the penalty? Let me explain a bit more. Section 100, subsection 2 says that a trademark shall be deemed to apply to goods or services if it's used in any sign or advertisement, even your business letter or documents. So example, if you are running a watch shop, okay, retail outlets, and you're not a authorized, let me say, a branded like Rolex example, or Patek Philippe, all right? You're not authorized to use the name of the trademark. And if you use it on your signboard, okay, or maybe you put it onto the box, okay, but you didn't apply it on, you didn't actually make it, but you falsely apply onto the goods itself, all right? That is wrong, that is illegal. And when you're caught, you will be fined. So how much is it? Okay, for body corporate like a company, a fine not exceeding 15,000 for each item of goods bearing the falsely applied registered trademark. Okay, and that is the first offense. If you have a subsequent second offense, okay, that means you do it twice. Okay, this is the second time you do it, okay, you will be fined not exceeding 30,000 ringgit for each goods bearing the false trademark. Now, if you are not a corporate body, corporate, you are individuals, you will be fined 10,000 ringgit for each goods, all right, for each goods. So if the domestic trade enforcer or the enforcement officer came to your doorstep and then they confiscated 10 items of goods. So they can basically fine you, let's say 10,000 for one goods. So it's multiplied by 10 means 100,000. All right, you get me? If you get me, please thumbs up, please, for Zoom viewers. Can you hear me? Oh, yes, thank you. Thank you so much for your support. All right, for services, okay, this goes the same for services. Now we have the product, the goods, now we have the services. Okay, if you're not an authorized agent of a particular, let's say a particular bank, a well-known bank, I'm not going to mention who, and you use the logo without their permissions, of course, you will be fined as well. For body corporate, not exceeding 100,000, and if you are individuals, not exceeding 70,000 ringgit. Okay. So, making or possessing article of committing offense. Now, I mentioned about counterfeiting. Okay, counterfeiting is making, all right, to make that so-called counterfeit products. What happens if you are an innocent consumer and you bought that counterfeit products? In other words, you go to, you bought a counterfeit bags, okay? The H bag, I'm not gonna say what brand is that, all right? So what happened? So if you possess the counterfeit product or in custody, in control, all right, you will be fined as well, not exceeding, how much is that? 1 million ringgit or to imprisonment for a term not exceeding 5 years or both, all right? This is under section 101 Trademark Act. Please bear in mind, this is very important, especially if you are, if you are lovely single moms and you want to sell products online through, social medias, bear in mind, please bear in mind that try to sell genuine products direct from the registered trademark owners, okay? Don't involve in selling those branded luxury and fake item products, okay? You'll be fine. When I say you will be fined means you're not okay. You'll be fined, you'll be punished, all right? What happens if I import or selling, fake, falsely applied trademarks? So anyone under section 102 says that anyone imports into Malaysia for the purpose of trade or manufactures, offer to sell. When I say offer to sell means you put your products onto any platform, okay? Any e-commerce platform, and in the possessions and control of the goods with falsely applied trademarks, you will be fined, you will be penalized as well, okay? So if you're a company, you'll be fined, okay? 15,000 ringgit for each item of goods with falsely applied registered trademark. And if you're individuals, you'll be fined 10,000, not exceeding 10,000 per item of goods. Okay, now always remember, when you design a trademark, kindly remove that R away from your trademark. The R stands for registered trademark. And if you have not registered your trademark, please do not display the R sign or do not put any sign that indicate it's a registered trademark, okay, in Malaysia, or registered trademark. What happens if the trademark is registered elsewhere? Well, if you import into Malaysia, okay, the laws of Malaysia applies. So if you falsely represent the trademark is a registered trademark in Malaysia, you under section 104, you will be penalized again. You will be liable to a fine not exceeding 10,000 ringgit. So do not apply, okay? The previous act is 500 ringgit. So that increase it from 500 ringgit under the old act to 10,000 ringgit, all right? So let's talk about the enforcement here, okay? This is something very new. Now, if somebody infringe my trademarks, what should I do? Should I get a lawyer? Should I, where do I make a complaint? Now, the old Act doesn't provide any avenue to lodge a complaint. Okay, the old Act, you have to do it under the TDA, the Trade Description Act. However, to make registered trademark owner and to protect the interests of the registered trademark owner, you need the law, a government actually enacted, allows and do an amendment which includes the enforcement for the trademark, for registered trademark owner. Okay, the following slides I am going to share with you will touch on the enforcement for the trademarks in Malaysia. Section 111 and subsection 1. So Chinese say 四條一, okay? Remember this, okay? 1111, all right? TM Trademark Act. Assistant controller means officer from the domestic trade ministry, basically the enforcement officer. They call themselves controller, okay? So you have the chief controller, you have the deputy controller, and you have the assistant controller, okay? So the assistant controller here, I'm going to put the word A and C here, so it will indicate that it's the assistant controller. Now, section 111 gives the power to investigate on every assistant controller. Okay, so he's like a police officer. He can exercise any kind of power, you know, when to undertake any investigations. Okay, to investigate any complaint, even in his own capacity. Okay, with or without the complainant. Now, 112. Okay, when your registered trademark, now listen very carefully, yeah, okay, for the trademark owners, okay, for trademark owners. Section 112 gives the provisions, okay, the protections to all the registered trademark owners. Okay, any person, any registered trademark owners may lodge a complaint to the assistant controller. Okay, may lodge a complaint to the assistant controller to conduct an investigation if there is any suspicious alleged, okay, counterfeiting or maybe falsely applied trademark or any offenses committed under the Act. That is under 112. All right. Now, 1121, if somebody is copying exactly your trademarks, so you can, under 1121, you have the authority, you have the rights to lodge a complaint. What happened if the trademark is very similar, but it's not identical? Okay, and of course the assistant controller in this case will refuse to investigate or refuse to act on it unless, okay, unless the registered proprietor, that means the complainant, must first sort the registrar verifications. Okay, now you see those days under the TDA, under the old Act, there's no provision for enforcement like this. And so what they do is that complainant must first get an order from the court or the session court, okay, to get what? To get the TDO order, the trade description order. In the case where there are similar trademark infringement, but they're not identical, they're just similar. So because the assistant the enforcer, they don't want to take up the case, they're afraid that, you know, they might exercise in the wrong judgment. So they would ask the complainant, why don't you get your lawyer to go to the court and get an order so that I can act on it? And this will take time, money, and a lot of efforts, all right? Because we have to prove to the judge that, hey, judge, these two things are similar, are quite similar and quite confusing. So the judge have to agree to it. Right now, we have a cheaper, more effective, and better avenue under the new Act, okay? Now the registrar of trademarks in MIPO, they can do these verifications for you. You just have to pay them some money, okay, officially, not the under table I'm talking about, the official fees, all right? Through a proper channels, we have to submit a forms and they will do the verifications to see whether these two trademarks were actually identical or similar, you know? And of course, they will give an order, a result, okay? They will give a letter to, of course, you can use the letter and submit to the assistant controller. Look, the registrar agrees that these two are very similar, and please carry out your duty to investigate, okay? So this one will save you a lot of money and efforts. Now, if someone infringe your trademark, my advice for you is that, okay, when you can actually go to enforcement departments to file a complaint under section 112, as I mentioned, and or you may maybe look for, before you file a lawsuit, a civil lawsuit, I may advise you to file for this, go under the Offences Act, okay? Just go and get somebody to confiscate, seize their goods and fine them, all right? Now, under section 113, subsection 2, okay, of the Trademark Act. Now, this is the power of the assistant controller. As I said earlier, the AC has the power, a similar power like a police officer. So the police officer can stop you, can request information. The investigating IO can request documents, information from you. All right. So under 113 of the Trademark Act, it gives the power to the AC to ask information from you, and whether you have to produce it in the physical or electronic forms. Okay. And then you have to present, you have to appear before him if he requested to give maybe oral statement, okay, or produce any document. So he has the right to summon you to come and see me, all right? To see him, not me, sorry, to see the assistant controller. I said already, he's like a police officer, right? So the AC may retain documents, okay? He may retain any documents necessary during the investigation. Of course, he may also retain the certified copy of the documents, and it is admissible under the law as part of the evidence in the later court, okay? Now, giving a false and misleading information to the assistant controller will be an offense. So it's under section 117. Under section 117, providing false and misleading informations and documents and evidence in the course of investigation will be an offense, and once caught, the penalty will be not exceeding 100,000. So don't play, when the AC call you before the office, be honest and give all the information, because he will check. You give a wrong information, you get it, okay? 100,000. Now, the new law provides under 119, it provides the power of the AC to arrest. Actually, it's with or without warrant, okay? Listen carefully. Assistant controller, I'm talking about it. When I mention AC, means the enforcement officer from the enforcement unit of the domestic trade. Under section 119, if he has reasonable grounds to believe that someone is committing an offense under section 99 to 102, he may arrest the person. Hey, I'm talking about arresting a person, an individual, okay, or many individuals. He may arrest any persons, but after the arrest, they must bring in them to the persons so-called arrested to the nearest police station. And how the police will deal with this detainee, they will detain them under the CPC, the Criminal Penal Code, okay, procedures of Malaysia. All right. So for you guys as a registered trademark owners, congratulations. See, the Parliament has amended the law to actually protect, registered trademark owners. So you have the assistant controller at your side. Under section 120, all right, assistant controller may, okay, they may go into any premises. They may enter any premises other than premises used only for dwellings, that means residents, okay? They cannot go into your house without a warrant, but they can go in and inspect any goods in any premises, your factory, your shop lots, your retail outlets. They can go anywhere, okay, and seize and detain goods, okay, for investigations. And if you have a vendor machines or you have a container, he may require the person in control to open the vending machines or the container. Now, if you not cooperating and if he couldn't find that person, okay, under the law, he may have the power to open it himself. He can force open himself, okay? Under the new 121, section 121, the magistrate may issue warrant in order for the assistant controller to enter any premises with or without assistance. So you see, when you get your AC by your side, it's very good for registered trademark owner, okay? Because you can get the enforcement unit to arrest, seize the goods, and let the government will deal with them, okay? Maybe send them a summon, okay? Denda berapa ratus or something like that, okay? So, and the assistant registrar may actually seal up any premises or containers and or goods if they think that it's too heavy to move around, to take back to their store. So any attempt to move or tampered with the sealed products will be fined not exceeding 100,000. Okay, what if I obstruct and I assaulted an officer when he actually undergoing his investigations, okay? Or maybe he's trying to arrest somebody or try to detain or seize the goods. No, if you see, if the enforcer came to your factory and you refuse to give him access to your premise for investigations, he will send you a compound of not exceeding 100,000. All right. So this, okay, that's all I want to say for the chapter 1. Please, I'm not finished yet. Okay, I'm going to start with the chapter 2. Okay, now you have the liberty to go to the washroom and maybe take some snack with you. So I'm going to start now. Okay, I'm uploading the slides. In chapter 2, I will be I will be talking about the grounds for refusal. Okay, in the previous chapter, yes, we talk about ownerships, we talk about the benefits under the law for protecting the registered trademark owners, criminal offenses, enforcement, and we talk about the rights to the property. All right, so we come back to the examination part. Okay, remember I told you about every trademark you have to undergo substantive examinations, and this will take you up to 6 to 8 months or 12 months. Okay, I'm not trying to cover up, but I'm telling you the truth. All right, all substantive examinations will probably take you more than 6 months, 8 months, or maybe a year, or in some cases it will be more than a year. All right, in many cases it will be more than a year. So why take so long? Why the substantive examination took so long? You see, every examiners, they have to conduct examinations on your trademark applications. And of course, there are many reasons why they object to your trademark applications. So let me just share with you 2 of the reasons today. I divided the grounds for refusal for okay, so that you will understand, and then when you design your own trademarks, when you file for your own trademark next time, all right, you will bear in mind, and then you will take my advice not to go against any of these grounds for refusal. Otherwise, you will not get your trademarks registered. Okay, you won't be penalized, don't worry. Okay, this is they won't penalize you if you get a refusal for trademark registration. They just refuse to register for you. So without wasting much time, I will start with the absolute grounds for refusal. Okay, absolute grounds for refusals. Okay, now in the previous slides, in the chapter 1, did I mention that a trademark must be distinctive, must be distinctive, or must be capable of distinguishing goods and services? You see, under section 23 of the Trademark Act, okay, a registrar will not will refuse, okay, to register any trademark if, number one, the sign means the trademark, okay, the mark itself, the logo, the representation itself, are not capable of being represented graphically, okay, maybe it's a bit blur, okay, and not able of distinguishing goods or services. All right, that's the tricky part. Not able to distinguish goods or services. Number two, the trademark devoid any distinctive character. No distinctive character. Okay, you see, when talk about distinctive means what features will make people recognize your trademark? When people look at your trademark, they see, oh, this is your trademark. This is called distinctive lah. Okay, in other words. So if your trademark does not have the ability to distinguish goods or services, then Section 23 will step in, will say, registrar will tell you, I'm sorry, I couldn't allow registration for your trademark because it's lack of distinctiveness, all right? So another thing is many of my clients always, make these mistakes when you file for registration. Now, your trademark should not consist of words like, or maybe any descriptive words as to the quality, quantity, the purpose, the value, geographical names, okay, or the characteristic of the goods and services, okay? Say, for example, I want to register Kajang Satay. I'm selling satay. For those of you from overseas, from China, Kajang is the name of a place, just like Shenzhen, just like Guangzhou, okay? Satay is a Malaysian favorite, one of the dish, just like your ramen. Sorry, is ramen from China? No, ramen is from Japan. Anyway, okay. Can I register Kajang Satay? The answer is no. First, Kajang is a geographical name, origin. You're describing the geographical origin, and satay is basically the products, the character of the product itself. Okay, all right. And also bear in mind that for foreign applications, when you come to Malaysia, and also for Malaysians as well, take into consideration of the customary language in the territory. Now, if you're trying to register a phrase or a word maybe in Iban language, okay, also indicates some products here, so you might not get it. Chances is you might not get it. So it's a custom language, okay? It has become a customary language. I give you some example of the signs which are capable of represented graphically, okay? Now you have a two-dimensional trademark, colors, or this. And on the other hand, this is visual and this is non-visual. Non-visual, you have the sound, smell, taste, touch, blah, 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 okay? These are all examples of signs. Okay, let's talk about distinctiveness, okay? Now, when you design a trademark for your own self, I'm not going to teach you how to design a trademark because I'm not a graphic designer, but I'm a trademark, okay, attorneys, I'm an agent, I'm a consultant. I'm here to tell you what you should do when you registered your trademark, okay? When you plan to register a trademark, okay? Now, you see, on one side, the weakest here, and the other side, the strongest here, okay? Oh, with a short of one letter, G, okay, never mind. Generic words, descriptive words, okay, tend to be the weakest trademark, and it will not be registered at the end of the day, okay? All the descriptive, all the generic words, please don't use lah, okay? Don't use all this. Example, if you are selling, if you open a fruit store, don't call yourself Durian King or some durian like that. It's very descriptive, the word descriptive, okay? Generic means you are describing the generic terms of certain products or services. Do not use that, all right? So I give you a just an example here. The strongest point is always very fanciful, okay? Very fanciful words, all right? However, you see, You can apply, you can register Apple if you're selling computer, but you cannot register Apple if you just try to start up your own fruits company, or maybe beverages company, or maybe selling fruit store. Okay, that's the whole thing. Lack of distinctiveness. These are examples where trademarks are lack of distinctive. I give example from Vietnam, all right? But this marks possesses distinctiveness, the tree, okay? You see the graphically, okay, how it designed the R with here, all right? Now, these are those descriptive words that you should avoid when you try to design your own trademarks, okay? Listen carefully, all right? Especially young ventures, new products, brand owners, and all these things, all right? I know for the last couple of months during CMCO, whatever, you have made a lot of money, and then you try to, go big by creating your own brands. Congratulations, and nothing wrong with that. Okay, just try to avoid using all these, these examples here. All right, all this. Do not include all this into your trademark. Okay. Now it must be descriptive. Okay. Now this trademark is okay, because it's a bit, is an exceptional, okay? It's very distinctive. See, figures. You see, I took this example. So this was rejected 5-star for hotel services. You cannot register this 5-star for hotel services. I'm so sorry. And this is for noodle. And this chef here is trying to display the noodle over here. All right, if you can see in my slides. No, you cannot do that. All right. It's not allowed. This is in Malaysia. It's trying to register for class 30. No, you cannot do that. Now, on the other hand, these two trademark were registered mark. Okay, this is for the animal accessory, and of course, there's a chef here, but it didn't display any food here. It just put maybe a cover. So this thing, you may register. You may get it registered. So when you look at this, you think of barber shops, because why? This is an international sign for barber shops. So somebody tried to apply for this for salon and then barber shop. So sorry, no way. This is something that makes me very proud of, okay? Because I fought for Secret Recipe many years ago. In 2002, we managed to obtain the trademark registration for Secret Recipe, because I argue with the registrar and I went for hearings. I argue on the fact that the trademark has acquired distinctive character as a result for its many years of the use before the application date. Now, okay, so if you look at Secret Recipe, you will somehow think that, hey, this is descriptive, this is very generic, can I register that? So accept the fact that you really put in really huge effort to acquire a distinctive character. Acquire means that you manage to convince your consumer that that this is distinctive. Okay, the shape. All right. Example of the shape. No, you cannot register this for shoe. Cannot. But the bottle, yes. This shape is very unusual, very distinctive. Yes. Functional shape also cannot. Registered as trademark. Diamonds, no. Name of a place, a famous landmark, cannot. You try to register KLCC, you get objection. Okay, I mean the Twin Tower. So any marks that contrary to the law or in the public interest against the morality cannot be registered. Okay. So if you try to register a country, a name of a country, a flag like Swiss sands, no. Okay, you cannot do that. And of course, you look at this word. Okay, try to pronounce this loud and clear at home. And don't quote me. Thank you. These are offensive words and it cannot be registered. Okay, let's come back to the case study, interestingly, okay? This case is concerning Super Coffee Mix versus Unico. If you can see from my slides, okay, we have two big giants here. This is a Singaporean case. It's a very famous landmark case, but it's applicable in Malaysian context, all right? Now, we have on one hand, the plaintiff, the Super Coffee Mix manufacturers. We have on the other hand, the defendant, the Indo Cafe manufacturers under Unico Trading Private Limited, okay? This is a Singaporean case, I said, but it's quite applicable to Malaysia. In this case, we are talking about because Super Coffee Mix is suing Indo Cafe Coffee Mix over what? Over the use of coffee mix. Okay, the word coffee mix. So of course, in 1995, the plaintiff informed the defendant stop using coffee mix, and because they are using Indo Cafe coffee mix. I show you these two packaging here. And of course, in 1998, okay, the plaintiff sued the defendant over the use of this coffee mix. So of course, the defendant denied, passing off, and then counterclaim and try to expunge. Expunge means try to cancel off the plaintiff registered trademark or to impose a disclaimer over the word coffee mix. See, the whole idea, the whole battle, the legal battle is all because of the word coffee mix. Now we are discussing, the court is looking into whether the coffee mix should be disclaimed or should be what they call it, expunged. Now the first trial judge dismissed both the plaintiff and the defendant's claim. Okay, and what happened? Okay, and the appeal, of course, the appeal. And in the appeal, the court will have to decide whether the words are descriptive in nature. I'm talking about the use of coffee mix to describe 3-in-1 coffee products. And second issue is whether the word coffee mix has become common to the trade and was well known and established to describe the 3-in-1 coffee products. The effect of the coffee mix, okay? The effect of the coffee mix and all these things. See, it's very important when it comes to the court have to decide this. Why? Because if the court thinks that coffee mix is descriptive and common to the trade, then Super will be bye-bye, okay? So what happened? Okay, you cannot see this, but I can read to you. So the court actually held that the plaintiff claim already dismissed. They dismissed the plaintiff and they allowed the defendant's appeal. So Super Coffee Mix lost the case, okay? And Unico's appeal was allowed. Okay, in conclusion, that is the conclusion. And what the court say? The court say that the court held that the word coffee mix, while having a descriptive quality, no less been used as a trademark by the plaintiff. Okay, so it means that, in other words, in conclusion, okay, the word coffee mix was the descriptive word. Okay, and also, and it is a common in the trade. And not only that, the court actually imposed a disclaimer. You see, when you talk about disclaimer, Malaysia, you can file a disclaimer for all the common word use when you try to apply for the trademarks, your trademark applications. All right. If I want to file in like example, what should be? Okay, trademark to use satay. Okay, the word satay is very generic and common in the trade. So I can actually, when I file for the application, I can actually voluntarily disclaim the word satay because I know that the registrar would not have granted me the monopoly use of the word satay. So in this case, of course, the court actually directed the Singapore Trademark Registry to disclaim the word coffee mix because it's descriptive in nature. So as I mentioned to you, okay, ladies and gentlemen, you have to listen carefully when you design your trademarks, okay, for your own self. Don't try to use generic and descriptive words. Okay, be a bit more creative and fanciful. And of course, as I said, this is not the end yet. I have one last slide that I want to show to you. Okay, it won't take long to complete this because I know everyone is tired and I've been speaking for the past 1.5 hours. And I want to thank everyone here. You're a fantastic audience and you're fantastic listeners. All right, give all a big thumbs. All right, for those who join my Zoom for registered today, I'm going to give you a special surprise gift. All right, for those of you watching from Facebook, don't worry, next time I have to sign up early. All right, please sign up early for it. Now, let me go to the last of my presentation today. Okay, chapter 3. All right. Now, I'm not going to do this every day. So if you, and I do not record, unfortunately, I do not record my Zooms and my broadcast today. So whoever who watch my video, I mean, my Zoom, my broadcast today, or live from Facebook, you benefits from the knowledge that I share with you. All right. And then I hope that, and I trust that you can share among your friends. Okay. Now we go to the second part of the grounds for refusal. We call it the relative grounds for refusal. Previously, we called it the absolute grounds for refusals. And there are two parts to the relative grounds of refusals that the registrar may refuse your trademark applications. The first will be if there are any cited earlier trademarks. Okay, which means that there are earlier trademark, there are earlier applications, similar and identical application to your registration or application or pending application to your applications. It sounds very a bit confusing, right? Okay, put it this way: if there are any earlier marks, whether it's still pending or registered, which are quite similar or identical to your current trademark applications, then he may object to your applications. Put it this way. Second is that if you are trying to be funny and you're trying to apply to register a well-known trademark in Malaysia, then chances is he may object to your applications. Let me share with you the first one, the earlier marks. Okay. Section 5, of course, the definition for Trademark Act says that earlier mark means a registered mark or any international protected trademark in Malaysia. Okay, from Madrid Protocol or maybe from priority, from Malaysia application, etc., etc. Okay, a mark which is a well-known trademark. Okay, and includes. I think there's something wrong with my slides. They try to misalign, but I hope that you can see it from your side. Okay. Section 24, 1 and 2 of the Trademark Act provides that the registrar shall refuse to register a trademark if there is a likelihood of confusion in the public sectors, on the part of the public consumer, where there is a identical or similar earlier trademark, okay, which is designated for a similar or identical goods or services. I want you to focus on the word of likelihood of confusions and the goods and services, these two, okay? Because you see, under section 24, we are not just looking at the similar or identical marks. We also must take into considerations the factors like whether it is confusing, and of course, we are looking at the list of the item of the goods or services as well, applicable to the mark. Now, how do we determine the likelihood of confusions for trademarks? Okay. First, you have to see, is there any, ask yourself this question. When you compare these two trademarks, you ask yourself this question. Are there any similarities to the goods or services involving? Okay, are there any similarities to the sign in conflicts? Of course, we have to see from the relevant public and consumer sectors. And also we have to see others. But I would say that it's important first to determine the first three, 1, 2, 3 issues before we move on. Okay, let me share with you this ALBA group. Okay. I think they put a wrong case law here, but never mind. I can. Okay. This case involved Alba Group is trying to sue the registrar of trademark. It's a very old case. It's 1998 cases, but it's still good. All right. In those days, we don't call it MIPO. We call it Pejabat Pendaftar Cap Dagangan. Okay. In English, it means that registry, trademark and patent registry office. Now, this is a high court case in Malaysia, published, and is still very good until, it's a good example, precedent until, today. The fact of the case, let me just share with the fact of the case, all right? Alba, okay, is trying to register the trademark ADAX. Look here, ADAX. And of course, they encounter objections from the registry of trademark because of a cited earlier mark called DAX. Of course, the registrar held that these two marks are phonetically similar, okay, and likely to deceive and confuse the public, and therefore the trademark office disallowed. Of course, Alba groups, they are very unhappy about the decisions. They appeal to the court, the High Court in 1998. This is the court findings, and the High Court actually squashed the decisions of the trademark. So of course, the issue to be determined here is that whether the trademarks ADAX and DAX are confusingly similar. And how do we determine that? Okay, how do we know whether they are confusingly similar? So the court said that in order to decide the issues, you must look at the two words and you must judge by looking both at their look and their sound. Now, I'm going to teach you something, okay? You want to know whether the two marks are similar or confusing, or maybe are you going to infringe one another? The first thing you need to do is to look at you have to examine by their visual, by their look, and also by their sound. Secondly, you have to see the goods or services of these two marks. And of course, the court actually look at the nature and the kind of consumers who are likely to buy, the goods. And of course, the surrounding circumstances. Okay, so these are the 5 factors that the court will apply to determine whether these two trademarks are confusingly similar. In this case, it was held that the word ADAX and DAX are not distinct visually and not phonetically similar. So when you pronounce, you see the easiest way is you pronounce ADAX, DAX, totally different. When you look at the word ADAX, DAX, totally different. All right, and you look at the product. DAX is selling heavy winter clothing, and then ADAX is selling what? T-shirts. Two different nature of products, although it fall under the same class 25. But in this scenario, it was different because one is selling the winter clothing and one is selling the tropical climates T-shirts. ATAX attract local consumer. Okay, ATAX probably they sell at Pasar Malam. I just guess lah. Okay. DAX probably they have selective shops, specialty shops. Okay, so it was held that there's no likelihood of deception and confusion between these two marks. So you see, I really pity this plaintiff. Okay, the plaintiff for this case, because they have to spend a lot of money, go all the way to High Court, and then come up with these very wonderful decisions. And this is a precedent for our for IP, for IP practice. Oh, another one is very interesting. I hope to get your attention. This is involving Bata Malaysia, Bata Limited, and SIM Aba. Okay, this is a 2006 case. This is quite an interesting case. Now, in this case, what happened is that the appellant here, or the plaintiff here, is called Bata. Bata, is a very famous, big international shoe giant. So they have this brand called Power. All right, and they're registered for shoe, boots, slippers, sandals, etc., etc. On the other hand, you cannot see this. Never mind. Okay, you have the defendant, Sim Aba, Mr. Sim Aba. I think he's from Ipoh, if I'm not mistaken. Well, he registered for this trademark here. Also carried the name, the trademark Power. Okay, but for shorts, stocks and underwear. For socks and underwear. Now, headwear, shoewear, footwear, and clothing fall under the same category, class 25. Okay, so both of them fall under class 25. And Bata, of course, came in first. And the registry actually allows the registration for the Power for Simaba, Mr. Simaba, the defendant. So, of course, Bata is not very happy. Of course, Bata actually is suing Simaba and also filed a motion to expunge and to remove the respondent trademark from the register. Okay, so meaning that Bata is trying to get an order from the court to remove completely, to cancel Simaba's trademark here in this case. So the issues to be determined by the court will be whether the respondent trademark Power was likely to deceive and cause confusions to the public. Now, this is all Malaysian trademark cases, okay? They are mentioning these are all landmark cases. We have been using this for again and again, all right? It's like a recycle, bin, but it's still a good precedence. Whether the respondent trademark was a distinctive in nature, all right? So this is the first issue, and it's the most important issues, okay? So they want to see whether Simabas actually infringe Bata's, trademark. Of course, the court actually summarized the factors to be considered in this case. Okay. Now, the first, of course, they're talking about the original registration of the respondent was obtained by fraud, and whether the respondent mark is likely to deceive, causing confusion to the public. Okay. And offensive matter. Okay. I think the issue 2 is more important that we are discussing today. Okay. So we also consider in this case, the judge also used the factors to consider the likelihood to deceive and cause confusion to the public. First, they look at the ideas of the trademark. And of course, they look at every element of the trademark must be taken as a whole. And we talk about the imperfect recollections, and we look at the visual and the pronunciations of the trademark, and of course the consumer aspect of it. So what's imperfect recollection? Let me just give you some hints here. All right, let me give you let me explain. Imperfect recollection means, all right, see, when you look at A products and you really recognize A's brand, A trademarks, and when you look at B, okay, B's trademark, in that moment of your memory, would you relate B to A? If the answer is yes, then there will be a confusion. Then there will be infringement. We call it the imperfect recollection test. Okay, meaning that they use the memory of an ordinary consumer to judge and see whether this confusion arises. All right. So it was held that, let me just give you a conclusion of this case. It was held that neither appellant nor respondent had a monopoly over the use of the word power. So the court in this case held that, just like coffee mix, the one that I mentioned to you earlier. All right. In this case, it was held that nobody can monopolize the word power. Why? Because it's generic and it's descriptive. As I told you many times, look, okay? People spend a few $100,000 of court fee, legal fee, and these are the lessons that we learn. Now, you just sit back, relax with your coffee, or maybe your tea, or maybe your orange or fruit juice, and you're watching this video, and please learn something, yeah, okay? These are the precedents, the real case precedents, yeah, okay? So the High Court held that nobody owned the monopoly of the word power. Therefore what? Therefore, in conclusion, that I can tell you, Bata lost the case. Okay, because he couldn't prove any infringement. He doesn't even own a monopoly the trademark power. Okay, so he lost the case. Yes. All right. That's a conclusion from the case. So we look at the visual effects. You look at the word sign, figurative, three-dimensional color signs. Now, I give you some example of the conflict of marks, okay? Some examples, just give you an idea so that next time when you try to register a trademark, okay? And remember, you know that, you don't try to be funny and try to, say that, oh, it looks like me, doesn't look like me, don't do that, okay? Don't do that. Because anything that, looks like you or sound like you will be you, all right? Let me give you an example. Two purely word mark, spark and spark. This is a C letter and this is a K letter. Are they identical? Yes, they are the same, all right? They are exactly the same. A pure word mark and a mix, okay? Sweet Valley, okay? Same. And this sign here with the word, one is JAL, Japan Airline, we know that. And one is called Kawaki, is it? I don't know the word, but you see that, it's like a mirror, okay? You try to mirror the trademark, it's the same, okay? So this is not gonna work. Same for this two little cute lion here, all right? Now, phonetically feature, try to pronounce the two words and see whether it's the same, okay? Conceptually, okay, Penta and Jaguar and all this, okay? Dark room, dark sense. Now, Jamie, James, Carol, okay? Jim 1000. So if I put Jim 1000, no, you cannot do that, okay? MK 200, MK 2000, no, you cannot do that, okay? And the figurative. If someone registered for Red Samurai and you try to come up with a figures like this, you will get objection as well. Because by reading the word Red Samurai, I can figure out it's you, okay? Red Bull, okay? These are examples provided by the Philippine IP authorities here. So the relevant consumer sectors have to be taken as well. And okay, I'm not going to go into deep of this, okay? I want to jump straight to this well-known trademark, okay? The last one. Let me show you some examples of what happened in reality. I think these pictures were taken in some part in the world. I don't know where is that, okay? The Starbucks cafe, sorry. All right, you like this? Give a thumbs up. Oh, sorry, this is a bit rude, okay? 7-Eleven, 7 elephant, okay? MFC, KFC, whatever it is. All right. Okay, this is cool. Okay. All right, Pizza Hut. All right. Now, can I register a well-known trademark? Let's say, example, if I would say example, let's say I take example of a Toyota. We know Toyota is a very well-known, automobile manufacturers in Malaysia. Basically, they produce car, vehicles, spare parts, everything. So can I register the word Toyota if I'm selling fruit juice for my fruit juice, okay? I'm selling apple juice. I want to call it Toyota. Can I do that, okay? Or maybe I call this, what are the good example of it, okay? I just call it Mitsubishi or Toyota, whatever, okay? Can I do that? Well, the answer is, first, all the well-known trademark in Malaysia, okay? In Malaysia, I'm talking about Malaysia, okay? You cannot do that, okay? Registrar shall refuse. Under section 24, subsection 3, your registration will be refused if you try to register a trademark which is well-known, identical or similar with a well-known which is not registered in Malaysia, okay? And you try to do that, and of course, you're not gonna get it. And of course, I understand that many foreigners from other country like China, or maybe from part of the world, if your if your trademarks, if your trademark has been a well-known trademark has been, let's say if you are well-known in China, or maybe you are well-known in United States, or maybe you're well-known in UK. If someone in Malaysia registered the name, can he do that? It depends. It depends. We have to see whether whether your trademark is well-known in Malaysia. Okay, well-known in Malaysia. So of course, how do we determine that what is well-known actually in Malaysia? Under the guideline, of course, is the degree of recognitions, public recognitions in this country, in Malaysia. Okay, again, I emphasize the word Malaysia. Okay, M-A-L-A-Y-S-I-A. Okay, not Singapore, not Thailand, not Indonesia, not China, not everywhere close. It's recognitions in Malaysia. Okay, so if it's not well known in Malaysia and it's well known elsewhere, okay, yes, you can register the mark in Malaysia. All right, technically, yes, you can register the mark in Malaysia. Okay, and very unfortunate for the foreigners, but very fortunate for you. Okay, but I'm not trying to teach you how to go about this, but I just tell you that in order to qualify as a well-known trademark in Malaysia, you must possess a degree of recognitions from the public in Malaysia, meaning that the people here must know you, your brand. Okay, okay, understood? So it doesn't matter whether you spend how much money of advertisement, promotion, AMP, etc. in India, in Indonesia, or in elsewhere, but you're not, nobody knows you here. So sorry, you cannot claim protection under the well-known trademarks. Okay. So of course, there are many evidence to prove, and otherwise, I give you some example of this. All right, I'm not going to go one by one, but basically, I just want to share with all the manufacturers, SMEs, business owners, and trademark brands owners here. Please document and keep a good records of your advertisement and promotion, or maybe publicity spending, okay, for a couple of years. Because when you want to sue somebody next time, it is very useful, okay? You can take it out and then you can use that as an evidence to claim there's some damages from the infringers, all right? This is my advice for you. And then, of course, it comes to the end of our seminar today. So sorry that we don't have Q&A sessions today because it's going to be one way. And the time here now is 9:50 p.m. I thank every one of you here, especially in this Zoom chat room, Zoom meeting. Wonderful, because you have stayed on like for the past almost 2 hours. All right, I think everyone should give ourselves a big thumbs up. And then I thank you so much for let me put this back to my screen. How do I put this back to my screen? Should I just, hey, how can I put this back to my screen?